Possiamo riprendere, Antonio? Bene. E allora, riprendiamo con i lavori. Innanzitutto...
So, we're going to resume.
Allora, riprendiamo i lavori.
I would first of all like to start by thanking Professor Pisani. His introduction has been complete and has certainly made my presentation easier. So, what am I going to deal with? Well, actually, I'm hopefully going to briefly compare the rules in the private international law, so Law 218 of 1995, and the rules as in the regulation number 1103. You know that the 1104 regulation about registered partnerships is basically one that mirrors the previous one, and the problems I'm going to deal with are more or less the same for both regulations. I have used different colors for the sake of simplicity. So red to show some criticalities, green to show what the regulation makes it easier for us. So the first criticality is about the applicable law. Actually, let me read from Article 69 about transitional provisions. It says, it talks about, it deals with the rules about the applicable law and all the general principles that Professor Pisani has already dealt with as to the choice of the law applicable to matrimonial property regimes. So this only goes for the spouses having contracted their marriage on January the 29th, 2019, or further to that. Sorry, there's a technical problem, apparently. We're going to resume in a minute, but we'll have to share the presentation also online, and that is apparently not being the case right now.
Perfetto. Condividere di nuovo? Sì, esatto. Quindi dovrebbe essere questo. Sì, ma non ci arrivo. Andiamo. Sì, perfetto. Sì. Allora dicevo questa.
So, as I was saying, January the 29th, 2019, well, that's a bit unfortunate, but the date has then been the object of some changes. Anyway, the regulation applies to marriages being contracted as of January the 29th, 2019, or to the spouses who further to that day have chosen a given applicable law, which means that for all marriages being contracted prior to that date, the applicable rules will come from the private international law. This is a criticality, though, because it basically means that we have two parallel systems, of course, each of one having its own difficulties. I'd like to stress at this stage that the choice of the applicable law is covered by the regulation. So the rules about the applicable law as of January the 29th, 2019 are the ones included in the regulation and not in the international private law.
Ok, quindi questa prima criticità riguarda l'applicabilità dei regolamenti.
Now, as for the general characteristics of the regulations, well, Professor Pisani has already dealt with the issues of universality, of unit, of no renvoi, and of no automatic change of the applicable law unless there is a specific will by the spouses, with one exception, though, that we're going to cover in a minute. As compared to the private international law scheme, well, that scheme was also universal. However, in terms of unity, well, this is something new that only pertains to the regulation. So once the applicable law has been detected, this applies to matrimonial regimes, matrimonial property regimes, as compared to the private international law. The applicable law could be detected, however, within the framework of a system of scissions. So for movables, the law basically applied as to, for example, the place of residence, but lex resida was the one applicable to immovables. Now, no renvoi. Well, this is what's possibly newest in the regulation, and it makes our life much easier, because you might remember what we were supposed to do with the private international law approach. The regulation makes this all much easier. As for the no automatic change of the applicable law, well, according to the interpretation of Professor Pisani, and apparently we share the same approach, the regulation, as clearly stated in the recitals, especially recital 46, which says that no automatic change of the law should apply unless there's the specific will to do so by the spouses. So that's quite new if we compare it to the old regime, which precisely envisaged, which precisely provided for such possibly automatic change. It was the law applicable in the place where most, marriage took place. I mean, actually, where the spouses mainly lived. So the law that pertained to the second state, the state of residence, was the one to apply. But today, thanks to this regulation, there's no such automatic change any longer. What about the choice of law now? As Professor Pisani has rightly said, recitals are very clear about that. Well, first and foremost, what shall be favored is the spouse's will. So the first and foremost, the first parameter envisaged by the regulation is the spouse's will. Spouses shall choose the, applicable law. Now, I think it is included in Article 22. No, actually, says the speaker, it's Article 23, which orbits around the formal validity of the agreement. Well, here are several criticalities. As we read in the article, the agreement shall be expressed in writing, dated and signed by both spouses. So, well, that's the minimal form, if you wish. Of course, any communication by electronic means, which provides a durable record of the agreement, shall be deemed equivalent to writing. But then, of course, the minimal form goes hand in hand with some exceptions, as we read in Indent 2. If the law of the member state in which both spouses have their habitual residence at the time the agreement is concluded lays down additional formal requirements for matrimonial property agreements, therefore those requirements shall apply. Or if the spouses are habitually resident in different member states at the time time the agreement is concluded, in which case there is an alternative approach. So one may choose between the most rigorous and the simplest form. And Indent 4 says that if only one of the spouses is officially resident in a member state at the time the agreement is concluded, and that state lays down additional formal requirements, well, then those requirements shall apply. So basically, in formal terms, there seems to be a sort of an overlapping, if you wish. So basically, forms are exactly the same when it comes to marriage agreements and law choices. Well, of course, what's behind all of that is the need for some protection, some guarantee, especially when the form is particularly rigorous. But what about the criticalities then? Well, here they come. Today, the regulation shall apply in all member states that have, received it as a national law. However, we may have a marriage contract and a choice contract that may be overlapping. I mean, this might be problematic to us because, of course, we may find it hard to understand about the date, about the truth of it, so to speak. But this is something that we must cope with sooner or later. Of course, unless both spouses come to see us. Of course, if only one of them comes to see us, then, of course, the problem arises, in which case we need to be cautious, as I'm sure we all know. But just think of one spouse who comes to see you and he or she is very much in a hurry. I have a separation of property regime. I can tell you it's perfectly true, reliable. And we say, well, I'm very sorry. We need the other spouse to be here too. I mean, this may give rise to problems, and to particularly sensitive issues that I'm afraid we'll have to come to terms with sooner or later. Better sooner than later, by the way. Let me move on because many of the things I was supposed to say have already been dealt with by Professor Pisani. So let me say now a few words about Article 22, about the choice of the applicable law. So I've skipped substantive issues that have been covered by Professor Pisani. So the choice of the applicable law, not many differences here as compared to our system. So the law of the state where the spouses or future spouses or one of them is habitually resident at the time the agreement is concluded. But what's new about it is the following, namely the possible retroactive nature of the choice. Unless the spouses agree otherwise, a change of the law applicable to the matrimonial property regime made during the marriage shall have prospective effect only, unless, of course, the spouses agree otherwise. Any retroactive change of the applicable law under paragraph 2 shall not adversely affect the rights of third parties deriving from that law. So third parties are safeguarded, of course, if that is possible, because we know that choosing a law also means choosing the legal framework that law envisages. So if I am a spouse, I may move from, communion to separation of property, which means that half of the property may be moved from one spouse to the other one simply through the choice of the law. And of course, this can only be done in a written form or sent via email through an electronic device. So that's a critical point indeed. Professor Pisani has widely covered covered this issue, actually. So the retroactive nature, this may be an issue for third parties. They may be safeguarded, but of course, if there's halving of the property that regards third parties, this may be an issue, that revolutionizes his or her situation basically overnight. And then fiscal issues, I might not dwell on that, but both Giovanni Liotta and myself are currently dealing with two different cases about this. I am really curious, about the taxation issue. I'm really trying to do my best to move the property. So the choice of the law, that's perfectly okay. I am only saying the spouses have chosen this law, and I'm using the fixed taxation regime. Well, it might sound very simple, but I'm afraid that is not the case. As for retroactivity, well, as Valentina will tell us later, if we think of a succession regime, if that is fiscally good, I may anticipate the moving of some properties to the spouse precisely through a retroactive choice of the law, without prejudice, of course, to the fiscal effects of all of that that are currently not very well known. So a private deed may have to be drafted, and retroactivity, they both account for two criticalities here. Let me now move on to the applicable law. If there is no choice of law by the parties based on the so-called objective criteria, so there's no choice of law by the parties. Article 26 provides for three different objective criteria. Actually, the second one applies if number one does not apply, and so on and so forth. So let me go through them. Once again, you'll see different colors based on the criticalities I want to signal. So in the absence of a choice of law agreement, the law applicable shall be the law of the state of the spouse's first common habitual residence after the conclusion of the marriage, or failing that, of the spouse's common nationality at the time of the conclusion of the marriage, or failing that with which the spouses jointly have the closest connection at the time of the conclusion of the marriage, taking into account all the circumstances. If the spouses have more than one common nationality at the time of the conclusion of the marriage, only points A and C of paragraph 1 shall apply. So, well, that's good enough for B, okay? Common nationality, well, that's, simple and clear enough. But A is an issue, because here the applicable law is the one of the spouse's first common habitual residence. What do we mean by that, first of all? There's no definition of that in the regulation. We know through the EU law that when we talk about this, we mainly mean the notion only used within the relevant regulation. So we'll still have to understand how to actually define within the framework of this regulation the notion of first common habitual residence. Well, in practical terms, maybe their children go to school in that particular place. Well, that is, of course, a common habitual residence. It's like locating, the spouse's marriage life. This is what usually happens. But the problem arises once the marriage has been concluded. What do we mean with the further to the conclusion of the marriage? Recital 49 says a little further to the marriage conclusion. Well, what do we actually mean by that? Well, we already knew that as in the Hague Convention on Matrimonial Property Regimes, this is one of the most complex sets of rules ever having been drafted. France, Luxembourg, and the Netherlands are familiar with this mechanism. So I asked some of my colleagues there. Well, actually, I got different answers. 2 months, 1 year. What is this further to the marriage conclusion? There's no definition for that. It is the single judge that can decide. So, in other words, this regulation sometimes envisages for the judge being the only interlocutor. Whereas we are, law practitioners, and we know that we must solve the issue also for, everyday issues, not only when litigations arise, for example, which may be a problem. So what would I do in practical terms if the spouses have not yet given a specific, common habitual residence? Well, I believe I would ask them to choose the applicable law. I would, quite frankly, not run the risk of, incurring in uncertainties. I mean, there must be an applicable law somehow, but we can't think of, having to wait for them to have acquired a common habitual residence prior to which time the other criteria shall apply, the following ones, I mean, because that would mean that prior to that time, the law may automatically change, which is precisely what the regulation does not provide for. Actually, a law shall be chosen, and that will be for good. So another criticality is given by the idea of the notion of the first common habitual residence further to marriage. I mean, suppose spouses got married in 2019, but I mean, we don't know as time goes by, which their first residence actually was. So we may have no certificates for that. So these are practical issues that we may have to cope with. Of course, the problem does not commonly arise. And then as for the closest, the closest connection, well, this is a notion that is already covered by the private international law, whereby a certain number of elements shall be considered in order to choose the applicable law. Now, this article 26, I'd like to repeat that, indent 3, also says that, as I said before, the judge may change the applicable law if there is a controversy, and of course, unless the spouses agree otherwise. In other words, if for a long time they have decided that their common habitual residence was different from the first one, and if they have decided then that is the applicable law, they may ask the judge to apply the law not of the first common residence but of the latest one. However, this is an exception to the rule. There's no automatic change, and the judge must come into play. So the objective connection criteria show some criticalities, and we've gone through them. And to conclude, if I still have some time, I'd like to say something about the opposability. Third parties effect. Actually, sorry, before that, about the notion of applicable law. As Professor Pisani was talking, something came to my mind, a possible case. We have 2 Italian citizens who get married in Italy. They get married in, say, 2022. Now, after a couple of weeks, they established and determined their first common habitual residence in Austria. So, which will be the applicable law for their marriage? Well, in my opinion, it will be the Austrian law, because it is the law covering their first common habitual residence. And actually, the regulation also applies to Italian citizens. I mean, all marriages having been contracted as of January the 29th, 2019. So, I mean, it's a theoretical case, but just think of two Italian citizens having got married in Italy. They may not fall under what provided for by the Italian law. Okay. Anyway, let's talk about third parties. Now, this is something that is typical of litigations, and there is a specific article covering possible opposability issues when it comes to matrimonial property regimes. So there's a general principle, some presumptions, and a default rule that applies when the previous one do not apply. So I'd like to say that differently from what envisaged in Article 30 of the Private International Law, there's no distinction between movables and immovables. Well, we know that immovables are those that we are mainly interested in. Well, we knew following that regime that in order for us to oppose that regime, a specific system was to apply, whereas here there are no distinction. And by the way, let us also remember the initial date covered by the regulation, January the 29th, 2019. So if the marriage was contracted prior to the date, I will use the previous opposability system. Otherwise, I will use the relevant and current regulation. So let's talk about this third parties effects. So if the third parties knew of that or should have known of that law in the exercise of due diligence, well, in that case, the law will apply. So the law, the regime law. But in England too, we read that there is a specific notion behind the notion of the knowledge. So the third party is deemed to possess the knowledge of the law applicable if that law is the law of the transaction between a spouse and the third party, where the contract of the state, where the contracting spouse and the third party have their habitual residence, or in cases involving immovable property, or if publicity has been complied with as included by the law covering the common residence or the place where the immovable is situated. Actually, we also read in Indent 3 a residual rule, so to speak. So where the law applicable between the spouses cannot be invoked by a spouse against a third party by virtue of paragraph 1, well, the effects shall be governed by the law of the state whose law is applicable to the transaction between a spouse and the third party, or in cases involving immovable property or registered assets or rights by the law of the state in which the property is situated or the assets or rights are registered. registered. So this article was envisaged because, of controversial situations. Here we have an acquiring party, a purchasing party, and we have a spouse. Well, the third party will be made aware of the regimes that apply to the spouse's situation. So we must check what the spouse says, of course, because the spouse may say anything, but we're not, any third party. We have a due diligence exercise that is located at a much higher level. So we are to guarantee, to safeguard the third party whose due diligence is governed through us. And of course, we must act professionally vis-a-vis both of them. Of course, this may drive us crazy. Therefore, I believe we should first and foremost check the publicity systems. Of course, the Italian one, because these may have to do with a transaction with a property being situated in Italy, and the one of the residence of the foreign spouse. I think this is something that we must really keep in our file in case problems arise at a later stage. And again, the problem arises only if one spouse is, has come to see us. If both spouses have come to see us, the problem will simply not be there. Now, to conclude, a couple of things. A couple of indications to consider, the set of rules about regimes. So first of all, we must know about the applicable laws. We must know about communion regimes, which may vary. In the case of a separation of property, for example, the spouse's house must be sold with both spouses' will. So, one must know about that. Anyway, at least for the European Union, a couple of indications. Some models have been drafted, and you can write here, the name of the website, and you'll see all, the list of the countries involved. But then there's another website, including 13 European countries, not EU member states. Well, actually, these are very simple websites, based on a question and answer approach. Very useful and definitely updated. As for the Commission on European Affairs, well, a publication was released in 2019. Of course, anything may change overnight, but this is quite well updated. We get some contributions regarding the substantive private international law in terms of marriages and registered partnerships for 33 European states. Unfortunately, the book is in English and French, but it can be purchased by having access to the relevant website. Well, it's not very different from the book we published on the prosecutors' offices. And by the way, the proceeds of these books will all go to, our friends in Ukraine. Actually, the first book was about proxies. So the proceeds will go to the Ukrainian colleagues who are living a very difficult time. And I'm done. Thank you.